Hello and welcome to a fresh new episode of Legal Wrangle on direct tax. Today we bring you 5 cases on relinquishment of the right to sue. Is it a capital asset? Exemption on income from trust property, capitation fee, criminal prosecution under Section 276D of the Income Tax Act and the Section 10A deduction. Our first case involves the assessee Satyam Food Specialities, now known as Karmic Business Specialities. The interesting question of law in this case was whether the relinquishment of the right to sue is a capital asset. Maneet has the case details for us.
The assessee set up an entire bottling plant to meet the requirement of its 1997 agreement with Cadbury Schweppes Beverages India to manufacture, bottle and sell beverages in Rajasthan. However, the plant was barely operational when Cadbury Schweppes sold its soft drink brands to Coca-Cola Company, which then transferred these brands to its wholly owned subsidiary Atlantic Industries, which is a Cayman Island company. The assessee was informed that all its existing agreements with Cadbury Schweppes India shall be honoured by the new owner. However, the assessee faced huge losses due to various sales disputes as Coca-Cola India was not interested in encouraging the sale of Schweppes brand competing with its own products. The assessee thus filed a complaint against Atlantic. Subsequently, the assessee entered into various settlement agreements. The assessee also received compensation from Atlantic for withdrawal of all litigation filed against Atlantic and Coca-Cola, as well as its right to sue them as the bottling agreement stood terminated. The assessee declared this payment capital receipt, not liable to income tax. The department, however, held that the entire compensation received by the assessee was settlement for termination of agreement, which was a revenue receipt.
The tribunal decided the case in favor of the assessee.
The tribunal held that the assessee had received compensation for withdrawal of litigation against the parties, which could have hurt their reputation besides entailing costs. Relinquishment of right to sue is neither a capital asset nor taxable under Section 28. Hence, compensation is capital receipt not liable to income tax. The addition was deleted.
In our next case, the assessee is Jasubhai Foundation, a charitable organization which showed income from property held under trust. The question in this case was whether income from such property held in trust could be claimed as exempt under Section 10. Maneet has the details.
The assessee had shown receipts through dividend income and long-term capital gain on redemption of mutual fund investment, which were claimed as exempt under Section 1033 and 1038, dealing with incomes not included in the total income. The assessing officer disallowed the claim, holding that this income was derived from property held under trust and exemption in respect of such income was allowable under Section 11. Only if such income had been applied for charity and not under Section 1033.
The Bombay High Court held in favor of the assessee. It upheld the tribunal order and dismissed the revenue appeal.
The Bombay High Court held that both Sections 10 and 11 form part of the same chapter. There is nothing in the language of these sections which says that what is provided by Section 10 is not to be taken into consideration or omitted from the purview of Section 11. Thus, income not included by assessee trust by virtue of Section 10 cannot be considered under Section 11. Revenue appeal dismissed.
Even as the school year concludes and new admissions are being sought into educational institutions, our next case deals with the rampant issue of capitation fee. The assessee is a charitable trust that runs about 8 recognized educational institutions and had shown receipt of contributions from students admitted under the management quota. The question was whether these contributions collected as donations were involuntary or demanded and in the nature of capitation fees to justify denial of exemption under Section 11. Maneet, we believe, has the facts of the case.
The department conducted a search operation of various premises of the educational institutions and also the residence of the chairman of the trust. Cash was seized from the chairman's residence, which was declared as his personal income received from petrol pump operations. Several documents were seized from institutional premises. In response to show cause notices, the assessee filed returns showing voluntary contributions received from family friends, corporate bodies, patients treated in the hospital, as well as parents and relatives of the students admitted in the management quota, which was claimed as exempt under Section 11. The assessee admitted nil income for all the assessment years. The assessing officer held that the assessee had collected huge amounts of capitation fee in the guise of donation. These contributions were not voluntary and no receipts were given. The assessing officer thus worked out the income of the assessee trust by estimating the collection of contributions on the basis of number of seats in the management quota. He thus computed the capitation fee at an amount which was higher than the admitted figure of donations actually shown to have been received by the assessee for each assessment year.
The appellate authorities held in favor of the assessee. Revenue raised the issue before the Madras High Court, which concluded that there was no evidence against the assessee and dismissed the revenue appeal.
The Madras High Court held that the AO had not conducted any inquiry. The department had not made out a case of collection of capitation fee in the guise of donation against the assessee. Yet, the AO had estimated the collection of contribution. Determination of tax could not be based on such hypothetical conjectures. The authority had also confused himself with the admission of students in management quota with the carrying on activities of the trust. The seizure of cash from the chairman's residence was assessed as his undisclosed income, which ended the issue. It had no relevance to the affairs of the trust. To invoke Section 13, the department should have focused on activities of the trust, which was not done. Hence, contributions claimed by the assessee as exemptions under Section 11 cannot be denied.
Obviously, clear evidence is needed to sustain any hard action against the assessee. This is true in our next case too, which involves black money and an assessee who made foreign bank account disclosures, either after being cornered or perhaps struck by a twinge of conscience. The assessee is Shravan Gupta, the managing director of real estate major Imar MGF. The question before the authorities was whether prosecution initiated against the assessee on a criminal complaint filed by the tax department under Section 276D may be sustained even after the assessee has produced the required accounts and documents. Manith has the facts for us.
The department issued several notices under Section 142(1) for the assessee to furnish details of the foreign bank account, including statement and transaction details. Following the assessee's failure to produce these accounts and documents, Revenue issued show cause notice under Section 279, read with Section 276D. The assessee claimed difficulty in obtaining copies of foreign bank account statements for the entire period of account operation, but finally furnished the entire transaction details on February 9, 2015. However, on February 10, 2015, the CITA authorized ACIT to institute a criminal complaint under Section 276D for the assessment year 2006 and 7. On February 12, 2015, a criminal complaint was filed against the assessee for willfully not furnishing the account details and documents as per the notice under Section 142(1) and thus committed offence punishable under Section 276D. The trial court passed a summoning order against the assessee.
The assessee stated before the High Court that he wanted to pay the entire tax of the disclosed account unconditionally. The High Court held in favor of the assessee.
The Delhi High Court held that the assessee had filed the bank statements a day before the department sanctioned initiation of criminal proceedings. Hence, the summoning order is liable to be quashed on technical reason.
The Delhi High Court, however, clarified that the department was at liberty to issue fresh sanction against the assessee after examining the replies, and in case of failure of compliance under Section 142(1), proceedings may be initiated against the assessee. Let's now move on to the last case of this legal wrangle. The assessee is HCL Technologies, a software development company with multiple units registered under a mother license. The question was whether each of these multiple STPI units registered under the umbrella of a single mother license may be claimed as an independent separate undertaking for the purpose of claiming the Section 10A deduction. Another interesting question in the same case was when the assessee fails to avail the benefit of a statutory provision like Section 10A. Can it be stopped from claiming the benefit in the future? Let's go to Maneet.
The assessee's 31 independent software development undertakings were registered under 13 licenses with the STPI authorities. Initially, the assessee claimed the Section 10A deduction by considering the 13 mother licenses as 13 eligible undertakings. Later, the assessee revised its return of income by enhancing the Section 10A deduction and showing losses. It now sought to treat each of the 31 STPI undertakings as an independent unit eligible for this deduction separately and individually. The assessee claimed that just because it had considered all the undertakings under the mother license in earlier years, it could not be stopped from making this claim in the subsequent assessment years following within the 10 period. The assessing officer disallowed the additional deduction claimed under Section 10A by way of revised return. He held that the units set up in earlier years were a mere expansion of the existing units as there was no separate approval as a new unit by the STPI authorities. The AO noted that the assessee had belatedly claimed these units as independent and separate without placing any evidence on record to establish that each unit had a separate bank account or separate books of account. The assessee had never placed on record the document seeking STPI permission. The AO thus restricted the assessee's claim of Section 10A deduction to 13 mother licenses and not the 31 independent and eligible units.
The case went up before the Delhi High Court. The court accepted the assessee's claim that failure to claim a benefit under a statutory provision like Section 10A initially would not constitute a bar from the grant of such benefit if claimed subsequently. However, the court held in favor of the revenue as the assessee had failed to establish that each of these 31 units was a separate undertaking with a separate STPI approval.
The Delhi High Court held that there was no evidence to show that the assessee had treated the 31 units as distinct undertakings. These 31 units cannot be treated as separate undertakings for availing Section 10A benefit.
With this, we come to the end of this episode of Legal Wrangle on direct taxes. You may email us your comments, counsel, or even criticism at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. It's free and will keep you updated on new posts. Keep calm, pay your taxes, and have a good day.